So, next up, I'd like to introduce Dr Nina Vaswani, Senior Research Fellow at the Children and Young People's Centre for Justice. Dr Vaswani's main interests include bereavement and trauma, and how this interacts with young people's experiences and interactions with the criminal justice system. So, give a round of applause for...
Okay, thank you very much for that introduction. I might need some help in finding out where... Oh, no, my slides are just there. That is good. Okay, so thank you very much for having me here this morning. I think many of you might not have been expecting me, and CYCJ Director Fiona Dyer is very disappointed that she can't be here with you today. So I'm here instead, and hopefully I can do her presentation justice, but I might be a little bit more reliant on my notes than I would wish to be, given I didn't know 48 hours ago that I was doing this. But yeah, it's very good to be here today. It's really great to hear about the work of the Sentencing Council, and I'm just going to speak for a little bit of time on children and young people and their kind of experiences of youth courts. So that is me. I'm not really going to dwell on the kind of policy landscape. It's very complex. There is a huge range of work and policy and practice that has been undertaken here in Scotland and elsewhere in order to improve children's access to and experiences of justice. Just to highlight the UNCRC, the United Nations Convention on the Rights of the Child, has specific Article 40 that looks at the administration of juvenile justice, and which states that children must be treated in a manner consistent with their dignity and worth, which considers their age and promotes their reintegration into society. It also states that all children must have a right to a fair trial, and that might look quite different for children because of their developmental stage. And that state parties shall promote and establish laws, procedures and institutions specifically applicable to children in conflict with the law. I think this is going to be covered later on in the session as well, but there has been a huge emphasis, quite rightly, on children's rights in relation to justice. But I want to talk about maybe a slightly later stage of development. Young adulthood, I think, is increasingly recognised as a distinct developmental stage, as we've been hearing earlier about some of the evidence that has informed the Sentencing Council guidelines on young people. So young adults are often caught in this liminal space between child and adult systems, in which they don't get the special protections that we afford to children, but they don't necessarily get the opportunities and entitlements that the majority of adults expect and receive. And I think this is particularly evident within the justice system, whereby young adults are often treated as adults, yet are still developing the physical, emotional and social maturity to assess risks, consider the consequences, make decisions, or fully understand and participate in justice processes. So subsequently, young adults are overrepresented in the justice system, they experience poorer outcomes in the justice system, and they are more likely to be reconvicted. And I think it's for these reasons that we would suggest that young adults do require some specific attention within the justice system. So it was really, really heartening to see the young adulthood given this specific status in Scotland within the justice system with the Scottish and Sentencing Council's guidelines last year. These sentencing guidelines, as you've heard this morning, recognise this developmental stage and place greater emphasis on rehabilitation. So taking into account the maturity of young people up to the age of 25, I would probably argue 45 might be more appropriate, but also taking a bit more of an individualistic approach to the particular personal circumstances of the young person and also of their offence. So I think youth courts are a really key part of improving this provision for young adults, and it's great to see that a number of problem-solving and youth courts that offer a tailored approach to young adults already exist here in Scotland, so in Aberdeen, in the Lanarkshires and in Glasgow. And I'll talk a little bit more about that Glasgow research because that's something that I've been involved in, but I know that colleagues who've been involved in the research into other youth courts are here today and can hopefully contribute as well. So as I said, I'm going to talk a little bit today about the work that the Children and Young People's Centre for Justice, and my colleague Karen here has been involved in that, the evidence and the research that we've drawn upon, the practice knowledge, the practice wisdom, the expertise that we've drawn upon to develop a blueprint for youth courts in Scotland. And that blueprint is available on the Children and Young People's Centre website. I'll post the link at the end, but you can certainly access that and look at that today. But just to touch upon the research into the Glasgow Youth Court, the Youth Court in Glasgow has been running since about June 2021. It works on a problem-solving basis, post-sentencing for 16 to 24-year-olds, with an emphasis on structured deferred sentencing, which has multidisciplinary intervention, support in the community, and regular court reviews in front of the sheriff. So the research that my colleagues and I undertook involved analysing the data on all criminal justice orders for under 21s between 2019 and 2022, looking at under 21s because initially the Glasgow Youth Court was focused on 16 to 21s. It's now been increased. The research involved 47 observations in court of 44 young people, 9 sheriffs, 3 courtrooms. We did 36 interviews, 14 with young people who had experience of the youth court, 12 with youth court staff, 4 sheriffs, and 6 others who were, third sector organisations, area team social workers who were supporting young people. We also undertook 10 case file reviews, and we also presented early findings and early integration of the data at an expert panel. And thank you, because I know that some of you in the room were there on that day to really give us advice and guidance on what the findings were telling us. And I suppose it's really important to note that the data highlighted key themes and a key shift in the way the court operates to include this explicit focus on age and maturation, but also a more flexible approach, offering second chances to young people. And that was something that we really clearly observed, much more flexibility and much more understanding that people do make mistakes and a bit more understanding of that. So back to this youth court blueprint, there has been a youth court working group. This was conceived by the Whole System Approach Group and the Children's Rights Implementation Group. And the working group, and I wasn't involved in this working group, so if I miss anybody of huge importance, then I do apologise. But it involved people from Social Work Scotland, Police Scotland, the Crown Office, Children and Young People's Commissioner's Service, and colleagues from CYCJ, and I'm sure many, many others who were involved in that group. So the blueprint has been approved by the Youth Justice Improvement Board, and it is very much a guide for what local authorities should consider when setting up their own youth court. So the blueprint is not prescriptive. It recognises regional variations in needs, resources, practices, and logistics. So the blueprint is aiming for consistency across Scotland, not necessarily uniformity. So the blueprint provides a whole range of recommendations, and I do stress that you should go and have a look at this. I haven't got time to go through all the recommendations today. I've probably spoken for too much already. I have all the recommendations on the slides, but I am going to kind of skip through some of them, but do take the time to have a look at that. The first... I would say the first rule of youth court is try not to use the youth court. I don't think that we are advocating that children should really be in a youth court. I think CYCJ's position, and hopefully Fiona will agree with me on this, is, and I think also the position that's been progressed by the Children's Care and Justice Bill, is that all under 18s are defined as a child and should be treated as such. All under 18 should ideally have access to the children's hearing system, and that we should not see any under 18s, any children in young offenders institutions. But we know that 16 to 17 and a half year olds who are not already engaged with the children's hearing system are frequently dealt with in the criminal courts, and there is underuse of the remittal to the children's hearing systems by the courts, as previous research has shown. So the first recommendation of youth court is don't use it unless you have to, and maximise the use of Scotland's children's hearing system. And I think even for young adults who maybe aren't eligible for the children's hearing system, we do want to see the maximisation of non-court disposals, including disposals such as diversion. We really do have to be careful that it's not a case of build it and they will come. So when we undertook research into the Glasgow Youth Court, it was really great to see this significant and sharp increase in the use of structured deferred sentencing for under 21s following the introduction of the Youth Court. And at the same time, there was a corresponding decrease in the kind of higher tariff use of community payback orders. So absolutely brilliant. But at the same time, there was almost a complete reduction in the use of diversion for this age group, so for the under 21 age group. Now, we never did get to the bottom of this, and this was one of the questions that we took to our expert panel. I suppose we should note that the comparison at the time that we were looking at after the youth court implementation was actually during the kind of peak COVID years, where there had been a big impact on the way that the courts were operating, which might have kind of painted an atypical picture in our comparison. So I'm not suggesting that there's no diversion happening for under 21s in Glasgow, but we just want to make sure, I suppose, that we don't increase footfall to the youth court at the expense of kind of lower tariff options for children and young people. Okay, so after that, youth court is a good thing. I'm not saying that we shouldn't use it, but if we can find other options, then that is always better for children and young people. But I suppose just moving into some of the recommendations that are in the blueprint. The youth court blueprint really recommends that the youth court is held in a more informal venue. So a venue outside of a traditional courtroom wherever possible, but otherwise in a smaller, more informal courtroom for children and young people. And it also recommends having a more inclusive layout and consideration of trauma-informed pupils, where the young person is able to be included, supported, and able to be involved in proceedings. The blueprint would recommend that children and young people should not be in the dock when they are in court. I have to say, in our 47 observations at the youth court, the vast majority of times the young person was in the dock, and they did appear to us observers anyway as to be very isolated from proceedings. In the very first courtroom that the Glasgow Youth Court was held in, it was a very large court, and the young person was off to the side in the dock. The defence agent actually had their back to them through the whole proceedings, didn't really make eye contact with the young person through the proceedings, and they did feel very, very kind of peripheral. You can see a quote on the bottom there, which is from a social worker who felt they were almost kind of set up in opposition to the young person who they were supposed to be supporting in the court. But I would have a word of caution. I think the Glasgow Youth Court did make important changes over the course of the research and over the past couple of years. So they made some important amendments to layout. When they were in the large court, which was Court 4, in some proceedings, the young person was seated in the well of the court at the table with the social worker, the defence agent, the FESCO. When they moved to a smaller, more kind of intimate court, the young person was in the dock, but it was in a different position, which was felt that they were maybe more included and certainly in the direct line of sight of the sheriff. But in both of these scenarios, the sheriff remained seated up at the bench, and actually, despite the young person sometimes being brought into that well of the court, the direction is always turned towards the sheriff. So actually, we were finding that even when the young person was sitting at that table, everybody was looking away from that young person and not really engaging with that young person directly. So even with these adjustments, they were still relatively on the periphery. So when we spoke to sheriffs about this, or about the court in general, there certainly wasn't really a desire from sheriffs to be seated at the table in the middle. I think there was a recognition that it was a formal proceeding. There were also probably valid security concerns. So I'm not sure what the solution would be, but it's something, I suppose, to be mindful of if you're establishing a youth court and considering layout. Another recommendation is about the right to privacy. So the blueprint recommends that the youth court is held in a closed court for the purpose of increasing young people's participation and reducing their anxiety. The children and young people we spoke to in the Glasgow Youth Court research found this aspect of being at youth court very, very stressful. They didn't know who the old people were in the room. Sometimes people were providing very personal details about their background and their experiences for good intentions, and that the sheriff would understand some of the things they have experienced. But these were very personal details that were shared with people in the court that they didn't know who they were. And we were there ourselves as observers. There would often be people from other teams or other courts there observing. We would see families who were there to support other young people who were coming through. We would see defence agents for other young people coming in and out, probably looking for their clients and coming back, and the doors opening and people coming in and out all the time. So it was very stressful, really anxiety provoking for children and young people. I'm really mindful of time here, so I'm going to whiz through some of these. In relation to the clothing that is used in court, the blueprint and a number of other documents, including the Convention on the Rights of the Child, General Comment 24, really advocates for the removal of intimidating legal attire. I think the evidence would suggest that the main benefit of this is that the young person knows who everybody is and what everybody's role is. But actually, the recommendations are that that can be done by explaining to children and young people who is in the room and what their role is. The young people we spoke to in the Glasgow research were less bothered about this than we thought. We thought this would be a particularly worrying thing for them, but I don't know if they've watched enough courtroom dramas on television to fully expect that people should be there with some wigs and gowns on. They felt that that wasn't as big a deal as we maybe had anticipated, but what was difficult was different sheriffs had different approaches, and so for the social work team supporting them, it was really hard to explain to children and young people what to expect. But we did have sheriffs who were much more informal, taking off the wig, taking off the gown. What was really obvious was that the other actors in the court, the other professionals there, were fully gowned up in fully kind of formal clothing, regardless of what the sheriff was doing. So in relation to children and young people's kind of participation, in the UNCRC Article 12, the child has the right to express their view in all matters affecting them. Specifically, they have the right to be heard in any judicial proceedings, which children and young people tell us that they really want that to happen. So some of that is about the need to be able to understand what is happening. They need to have the opportunity to express their views in the court. And sometimes even just the court layout made that very difficult. The acoustics of some of the bigger courts meant it was almost impossible to hear what was going on. One of the things is about preparing them, so ensuring that we can explain to children and young people what they can expect when they turn up at the youth court. So that consistency is key. But I do think we need to consider what is meaningful participation. So we did see all of the sheriffs in all of the hearings that we witnessed making an effort to engage with the young person, asking their views on how things were going, what they thought would help. So real direct engagement with the young person. But as you can see here, the huge power imbalance that is inherent in that experience for that young person. They are speaking to somebody who potentially has the person to take away the power to take away the liberty. You can see from this quote that they didn't really feel that they could maybe be themselves, or that they couldn't be honest about what they were thinking. So we do need to think about how do we meaningfully promote that engagement when it is always going to be a very stressful, very difficult situation for young people, regardless of how nice everybody is in the courtroom. Right, I'm realising I'm probably at time, so I'm just going to skip through. I'm probably going to talk about language, and then I'll probably skip through the rest. I'm happy to take questions at the panel, and also once you've had a chance, if you are interested to look at the blueprint, then my colleagues at CYCJ and myself would be really happy to discuss any aspect of that. But language, I think, was something that was hugely important. So we know that being able to understand what is happening is absolutely crucial for a young person's participation. And the kind of complex and legal language that is used in the court situation, it's confusing to me. So it probably is very confusing to children and young people, and it really does prohibit their participation. We also know that those with speech, language and communication needs and other kind of neurodiversities are overrepresented in the justice system. So that poses additional challenges to them as well. And what we observed in the Glasgow Youth Court research was that the sheriffs made a real effort to speak in relatively straightforward language to a young person. You can see the quote there from the sheriff that they're doing their best. They're really trying not to use legal language. They're trying to explain some technical terms if they do need to be used. But what we saw, and it's maybe just the stage that the Glasgow Youth Court was at, was we witnessed this with the sheriffs, but every single other actor in the court scenario used complex legal language. So whether it was the fiscal narrating the facts of the case, whether it was the defence agent speaking to the sheriff about the young person, there was a lot of speaking about the young person to in between the actors in the court, or also the sheriff clerk at the end. So when they're summing up the decision of the court, this was using really complex legal language and was also kind of rhymed off in a really quick fire succession. So the child was hearing this, which was the main decision of the court, and then they were kind of ushered out, and the next case was being called even before the young person had left. So while some parts are starting to change, I think there's a real emphasis on bringing everybody that's involved in the operation of the court system into that kind of knowledge and understanding. So I'm going to skip through these. The training for all, I think, links back to that bit that we're talking about language, I think there's been a lot of work with sheriffs. The sheriffs have a lot of power and control about how their courts operate, but we maybe need to make sure that everybody is brought along with that. And I will skip through all of those and say thank you. You've got the link there, but if you just go into the COACJ website, you can find the blueprint, and certainly happy to take questions later or afterwards. Thank you.
So thank you for a fantastic presentation. Next up, we have Professor Kathryn Hollingsworth, whose research interests include children's rights, particularly in the context of criminal justice systems. Kathryn has worked widely in the area and has a strong interest in judicial approaches to children's rights, including judgment writing and sentencing. She's also worked with the Judicial College in this area. So, introduce Kathryn. Thank you.
Thank you very much, Jay, and thank you to the Special Sentencing Council for inviting me to speak. I really am so honoured to be here and really delighted to be in this room of real experts. As Jay said, my background, my expertise, I suppose, is children's rights in the criminal justice system in England and Wales and across the scope. But what I'm going to speak about today is a qualitative study that I've carried out with children and young people, but young people looking back on their experiences as children. So these are children that have been in court, been sentenced in court, and I'm interested in the communication, their experiences of the sentencing process, but the communication that takes place, particularly in relation to the delivery of the sentence. So that's what I'm going to be focusing on today. But just by way of background context, in England and Wales, so I'm talking about children under 18s here. I hope that this has some resonance as well for young adults, I'm sure it does. But just in relation to children, we have about 11,500 children were sentenced last year in the criminal courts. Most of those take place in the youth court, about 5% in Crown Court. And of the total, about 5% of those sentencing occasions result in custody. We can see from this graph what a massive decline there has been over the last 10 years in terms of the number of children who are being sentenced in court. That's reflecting fewer children in the criminal justice system, and of course then there's been a requisite decline in custody numbers for children. This hasn't been as we've seen this decline, we've actually seen an increase in the disproportionality for children from racialised minorities in custody, and I think that's a really important thing for us to think about. The other thing I think that's really important to think about, particularly, I've been more concerned, more interested working with judges in the Crown Court, and this does mean that we've got fewer children in Crown Court, and that might have a knock-on in terms of how often it definitely has a knock-on in terms of how often some judges have children before them. Some courts will see children relatively frequently, others will not, and this will mean they're less accustomed to the sentencing framework, to the needs of children, and so on and so forth. In England and Wales, as I'm sure most people will be aware, we have a really excellent guideline for children and young people. So children and young people is used here for under 18s. It's not the same. It doesn't go up to include young adults. There is also 3 offence-specific guidelines for children, but the overarching principles, I think, which were revised in 2017, are widely considered as being a really excellent guideline, capturing all of the kind of key children's rights principles that we would want to see in a guideline and that we would want to see, of course, then translated into practice. So I've just identified the key ones there: prevention of offending, an individualistic approach, focus on rehabilitation, etc. This applies to, obviously, determination of sentence, what the sentencing outcome is going to be, but I think it's really important as well that it is used by judges to think about how they are delivering their sentence, and that these principles need to be captured and thought about in terms of the impact that sentence delivery can have on preventing children from offending, on their rehabilitation, and so on. And that's what I'm going to be speaking about today. I also just want to flag the recent decision of ZA in the Court of Appeal in England and Wales, because this was a really excellent decision from the Court of Appeal on sentencing children. The facts concerned a 15-year-old boy who had been convicted of robbery and received a 5-year custodial sentence. The problem with that sentence was that the adult sentencing guidelines for robbery, rather than the child-specific sentencing guidelines for robbery, were applied, and the child then consequently got a 5-year sentence. On appeal, it was overturned. The Court of Appeal said they didn't even think it may not have even crossed the custody threshold, so he may not have had to go to custody, and even if he had, it would have been at most 3 years had they applied the child-specific guidelines. But what's really valuable about this judgment is how Mrs Justice May, in delivering the judgment, sets out this checklist that should take place when delivering sentence for children, that includes also thinking about the practicalities. So some of the things that we've heard about this morning. So thinking about the court listing, so the court has sufficient time to prepare age-appropriate sentencing remarks. If it's an adult co-defendant, that they are sentenced separately, the courtroom setup, so the child is supported by their parent or another supporting adult, and that there should be, as we see in the judgment, a root and branch difference of approach when sentencing children, not only in working out the outcome, the sentence itself, but also in how it is delivered. And in particular, and my focus today is in terms of this communication, and we see here Mrs Justice May saying that when sentencing a child or young person, it means taking care to explain the sentence and the reasons for it to them, and that's an emphasis in the judgment, in a way and using words they can easily grasp. Remarks which properly speak to the child or young person before the court require time to get right, but experience shows it can make a real difference. And I'm going to talk a little bit about that, drawing on the interviews with children and young people themselves. I think here what I want to emphasise is it is not just about the clarity of the language, it's not just about avoiding legalese, though that is absolutely essential, it's also about these relational communication elements that are really important to children's experiences. So it's a small qualitative study that I've undertaken. My research questions broadly, how do children experience and make sense of communication, particularly during sentencing, though I did ask them about trial because I think that informs how they are going into sentencing as well. What their views of the judge are and judicial communication, and does the way that the judge communicates the sentence remarks matter to children, and why or why not. It was a small study, but I've got really rich data. I've got about 180 pages of data from this. They were long interviews with breaks, but as well as interviewing the children about their experiences, I also asked them to read, or I read to them, 3 different examples of sentencing remarks, 3 different styles of delivering sentence, and to get their reflections on it. That I found really helpful, for particularly when the children and young people saw the 3rd extract, which I'll show you, because it brought to life for them a different way in which sentence could be delivered. So this is the first extract, or an extract of the extract. I'm going to skip through it, but you can see there it's very stigmatising. This is not that long ago. This is one of the published ones, and also very complex language. The second extract was from a Court of Appeal decision called Chin Charles, where the Court of Appeal had rewritten the sentencing remarks that the judge had delivered, which were very long, and they were very critical of that, and they wrote it as an ostensibly clear way of delivering a sentence. You can see, but it's not stigmatising. Lots of numbers, which the children talked about. And then this one is a fictive example. This was written for me by the then chair of the Magistrates Association, very experienced youth court judge. I'd spoken to him about kind of what a children's rights approach to sentence delivery might look like, the kind of things we want to see. He thought about a typical case, and he wrote this letter to Joe as a sort of sentencing remarks. And you can see it kind of, it's talking about his future, it's recognising the struggles that he's had and so on, his family background. Now, there are 2 themes that I want to just draw on. The first speaks to children's experiences, and that's the theme I'm going to talk about is Inside Out. The second theme I'm going to use in a moment is kinder or kinder justice, and that speaks to issues of children's perceptions of legitimacy and the importance, I'll say, of recognitional legitimacy. But first of all, their experiences. So Inside Out, I'm channeling the Disney film for a few years ago, if you remember, with the cartoon characters representing emotions for children in their head. And there are 3 sub-themes to this. The first is just the sheer amount of communicative labour, mental and emotional communicative labour that children are engaged in the courtroom, much of which, as we see here from Trent, is not visible to the outside. I think this is important. Some research with magistrates about published by Lowenstein recently about their communication with children, if they feel that the child is disengaged, they can stop trying. And I think the children are not disengaged, is what I would say. They are doing lots of things. They're gauging the reaction of the judge to what they're saying. They're reading the room. They're engaged in emotional regulation, trying not to show the judge that you're angry, trying not to show sadness or distress. They're really concerned with what their families are hearing in the courtroom, and they're kind of dealing with that side of emotional things as well. And for some children, they are anticipating bias, so they're looking for cues that show them that the judge is going to be biased. Am I going to get a biased judge? Secondly, inside out I'm using to communicate this way of children feeling very much inside the spotlight, but outside of the communicative or participatory processes. Samuel here was a 13-year-old in Crown Court. He spoke elsewhere in the interview about it's all on me. He felt really under the spotlight, but you can see here a real sense. He was nervous, really nervous. It was quiet talking, quiet talking. They were whispering, I didn't understand it. I was like, who are those people? And he said, the judges. They were whispering to each other. This has a real impact on children. So Marcus here, you feel powerless. There's people in front of you, like 4 people just talking about in front of your face. And you'll be standing there. It's like you can't do anything about it. You just feel so powerless. So this really makes participation and effective participation really very difficult for them. And then the third aspect of Inside Out that I just want to flag is what I would call an all-consuming fear for all of these children, or most of them, some of them who were sentenced to custody, most were not, but they were fearful of going to prison, of that outcome. And so they're fearful of going inside, and what that represented for them was that their life would be snuffed out, their hope for the future, their educational chances, their childhood. And we see Nathan here really very viscerally talking about it being like turning off a life support machine. All of this is crucial because, of course, that stress, that anxiety that they're feeling is going to make communication so much more difficult for them. So this word cloud is their experience. When I asked them at the beginning of the interviews, how did you feel during sentencing? And you can see just how anxious they felt. This is important when it comes to judges communicating sentence, because there are ways in which that can be mitigated, changing the courtroom setup, giving the sentence outcome at the outset, for example, particularly if it's not going to be a custodial sentence, which may allow them to absorb better any other messages that the judge is trying to convey through the sentencing remarks. Providing them with written sentencing remarks at the end, or a letter to Joe. There has been changed in the criminal practice directions in England and Wales recently to recommend the provision of written sentencing remarks for vulnerable people, including children, and I think that should become practice, particularly in the Crown Court. I say looking at Rosa. So the second theme I want to speak about is kinder or kinder justice, and this is what is important to children and why. What they want to see in the judge communicate through the sentencing remarks in particular, but generally through that process. The first way I'm using this is kinder as an adjective to talk about a caring justice. And there are 3 ways in which children, my own research, data that the Howard League has shared with me, children being sentenced feel that judges do not care. That word was used so much, they don't care. And there are 3 ways that I think they spoke about what they did value. Care being taken over the decision-making process and communicating that to the child. Secondly, a judge who cares about the child, so talks about their past, understanding their past, understanding what's happened to them, and care for their future, having an investment in them. And secondly, judges who express care for the child, so through authentic kindness, and that was important, empathy, and so on. So various quotes here that show this. So Joshua, talking about the letter to Joe, the judge has done the research himself. He's done it personally. That was really important. He knew that the judge had read these reports, and he's showing empathy. He's saying, like, we all do stupid things. I've done stupid things as well. This investment in the future, give them hope, don't give them fear. It's how empowering this is for the child. If they feel, so Louis again talking about the letter to Joe, if you feel the judge is invested in you, that is empowering you. It feels like they're on your side, and I think that would help, he says. And then Grace, who did have a good experience with her judge, and she's recounting that experience here. He read like he actually cared. And, you know, when he was reading, you could see he was understanding a bit more. I actually started feeling good. I was still upset, but I was feeling good because finally someone is starting to understand. And these are the kind of quotes that are so powerful, I found in the data about how important, what a difference a judge can make in how they communicate. Second element of kinder justice, I'm focusing on the kin part, and this is the sense that children did not identify as a proper criminal. They differentiated themselves, particularly from adult criminals actually. They did not adopt that identity as a criminal. Even if they accepted they've done something really badly gone wrong, they saw themselves as a child who's made a mistake or whose circumstances are so constraining they had no agency in that space. And it's not the person, the way they're presented in court, both through the trial, but also in the sentencing remarks, they don't see themselves in it. And it was really important for them to feel that the judge in the sentencing remarks is seeing that child, seeing the person that their family know, that their kin know. And we see that from Trent here. And we see this again from Grace, again talking about the thing that made me want to prove myself was the judge. He didn't have to give me that chance. He's understood me a bit, and he gave me a chance already. It allows you to be a better person. And finally, my last point, the other thing that was really important to children, and I'm using kinder, in the kinder sense here, to represent children as a group, they did not feel seen as children, and that was really important to them. And we see from Trent here, whether I was a child or not didn't matter. That's honestly how I felt. And judges can change that, even if during the trial there's been a particular presentation of that child. When it comes to sentencing, adapt the courtroom, show them, tell them that that's why you're doing it, because you're a child, you have rights. Adapt the language, make them know that you're taking this approach because they're a child. Show them that you understand the difficulties of childhood now, show them you understand the constraints, and show them that we care about them because they're children going into the future. I think judges, you know, the communication of sentencing is not the be-all and end-all. Of course it's not. It's the sentence outcome has a massive impact. But I think it really was powerful for me reading the data and engaging with these children, what a difference it can make. I have worked with the Judicial College a little bit, been invited to do so originally by Rosa, and worked with some judges. And this is an example from a manslaughter case in the Crown Court where the judge has kind of really tried to, I guess, adopt some of these principles really powerfully. Also, this is just an extract. He talks very compassionately to the victim's family, of course, and then goes on to talk to the child, recognising that she's had a terrible life, she's experienced things no one should have to, telling her that he's read and reread the letter he wrote and so on, and that you do have a heart and you have a future worth living. This was a manslaughter case in the Crown Court, and I think this is incredibly powerful. It doesn't just have to be constrained to youth court, it can be in very serious offending as well. Thank you. Sorry, Jay, if I overran.